Swimming like a shark in a shrimp tank. Big fish, small pond in the shrimp tank.
Hey everyone, this is Mark Scribner. I'm your host of The Shrimp Tank, where book smarts and street smarts collide. Today we have an amazing guest. It's Lisa CUKIER. Hopefully I said that right. I had to practice that a couple times. I would like to remind all our listeners that The Shrimp Tank is nationally syndicated through iHeart, Google, Stitch, SoundCloud, YouTube, basically anywhere that you can get your podcast, you can follow this show. We would like to get your followership. So if you just smash that like button, you'll get alerts for future shows. We are in 13 cities across the country. It's become the #1 entrepreneur podcast in Boston. And we have some amazing guests. So with that said, today we have someone, in your life, there's really a couple times that can be pretty catastrophic. One would be death, another would be disability, but more importantly, divorce is something that's pretty disruptive for anyone that has had to go through that process. And we have an expert, someone who's storied in Massachusetts. Lisa is with Burns and Levinson, another amazing firm. They've been around for a really long time. And Lisa specializes in the divorce and also very complex, ultra high net worth families and some of the issues that they have to contend with going through a divorce. So with that said, Lisa, welcome to the Shrimp Tank.
Thank you so much. I'm delighted to be here.
So let's maybe if you could, for our listeners, just talk about what your specialties and some of the areas that you focus on over your career and maybe the length of your career as well.
Certainly. So I handle high asset divorce with complex assets, sophisticated assets. I handle pre-divorce strategic planning and protection of family wealth and business wealth, enterprising families and family offices. I also handle fiduciary matters. So I serve as trustee. I serve as guardian and conservator. My job is to make sure that family wealth is protected no matter what crises might intervene in life cycle issues. And there are many crises that intervene. Marriage and divorce is only one aspect of it. Sometimes there's diminishment of mental capacity that requires legal strategy and interception of crisis so that we can move things in a better direction when they're going sideways. So that's most of what I do. I handle a lot of blended family planning as well, especially involving late in life romance. So it's not just the midlife wealthy divorce that I handle, but also the late in life romance, where a potential new romance could upend years, if not decades, of long-held, steadfast estate planning, because as we know, matrimonial law will impact and sometimes adversely impact descent and distribution and inheritance laws. So in a nutshell, that's my practice.
It's very valuable. Let's break down, they're really from my day job being a financial planner and wealth management. But let's maybe break out the two, like the prenup kind of scenario, when people should potentially engage in that activity. And then I guess there's obviously the other aspects would be post-nup. And then, unfortunately, if there's a divorce. But if someone is considering a prenup, like when should that be all figured out and finalized? Obviously before the wedding, but like, what are some best practices there?
Sure. So let's start with just a basic proposition so that we understand why anybody would do a prenup in the first place. So in Massachusetts, any assets that you bring with you into a marriage, even if they were acquired long before you were ever married, it might be, for example, a midlife marriage where there have been prior marriages in the past and assets that have transferred through generations, long held 401k and retirement assets and business assets, maybe venture capital, whatever you come into your marriage with, all of that, whether family asset, whether earned, unearned, vested, unvested, coate, inchoate, it all comes in to the marriage as a marital asset, meaning that if you later get divorced, it is subject to division as a marital asset. And so one way that people protect assets that they have when they come into a marriage, or assets that they expect to receive because of inheritance, gift, trust interests, and other expectancies, The way to protect that is with a prenuptial agreement, and only with a prenuptial agreement. A trust won't necessarily protect it. A prenuptial agreement will take assets and segregate them and call them separate assets. I want to step back and let you know that prenuptial agreements used to be used in connection with estate planning. It was never a divorce tool. Years ago, they were not allowed in a divorce context. These are estate planning tools. And the idea was to keep bloodlines of wealth in the family bloodline. It was a way to prevent a shift in the assets to a widow or widower when the assets should actually revert to some extent back to the family rather than go out to new children or somebody else's family, the in-laws. That's what a prenuptial initially was.
How are those, I know different jurisdictions, different parts of the country, sometimes they're contested, like I think of like Kanye right now, right?
Yes.
You see the publicity about that and the Bill Gates, scenario, but how ironclad are they? I guess it's only as good as the lawyer like yourself that's creating that document, but are they typically ironclad?
They are enforceable. They are enforceable as long as they're fair and reasonable and based on a fair financial disclosure. So in order to be enforceable, in order to be ironclad, they need to have enough disclosure of the asset and income level that the other side knows what they're waiving. You need to know what you're giving up before you give it up by signing. And to your question initially, how far in advance as a best practice should it be signed? At least 1 month before the wedding. You don't want to sign it the night before because it would sort of look like duress and coercion. You've just planned your wedding and now you're asked to sign a document. It's best if it's been in the planning for months and if it's signed at least a month in advance, if not longer before the wedding.
And is it recommended that all parties retain independent counsel to have it reviewed, or does that matter?
It does matter. It is important because the court is going to want to know if an agreement, a prenuptial agreement, is attacked at the time of divorce, then one piece of evidence that would come into the divorce court at that time in the attack of the prenuptial agreement is, did you know what you were signing at the time that you signed it? And if the prenuptial agreement was signed based on advice of counsel, and if counsel's name is written into the agreement, so for example, it might say that Mark was represented by so-and-so, and the judge might recognize, oh, that's reputable counsel. You were well represented, Mr. Scribner. How can you seek to avoid this prenuptial agreement now? That's the impact that it does have.
That's great info. So, month or months in advance, like not under duress for the prenup part. Let's talk about stuff goes sideways and you're going to get a divorce, or you think the marriage is irretrievably broken down, unfortunately. What are some of the things that people should consider? Like if they were to call you and ask you questions, like what should they know? Because oftentimes people their hair's on fire or for whatever reason, but it's an emotional thing to go through, and the emotions are usually at the fore, I would think. But for questions like should someone ask someone like yourself?
Yes, so I recommend that people see me before they actually file for divorce, and see me before there are arguments within the couple where the D word, the divorce word, is used. Couples will say things to each other out of upset, fear, whatever it is, shame that the relationship isn't working, the sorrow of it, the fear of what's going to happen next, and will we be okay? And they say things to each other that actually become sources of strategic play in the future. So we want to be very careful to have clients not start slinging mud or talking about who's going to get what. The message should be a quiet message, and people should come to me early on before anything is filed and speak with me, because there might be some strategic ideas that I have that will help protect certain interests, such as business interests, custody interests, other financial interests, expectancy. So there's many things that can be done before a divorce is filed. Sometimes a divorce should be filed immediately because the mere filing and service of the complaint on the other side will create an automatic restraint on the party's ability to play with the assets outside of the ordinary course of the way that those assets were spent during the marriage. So that can be advantageous too. But I will tell you, I like when clients come to me early on, because there might be an opportunity for me to send the client or the client and their spouse to a therapist or a coach or somebody to help out. Even if the marriage can't be brought back together, perhaps we could have several sessions where we can put some ground rules on the table. Maybe you make an agreement to not have an acrimonious process. Perhaps you have an agreement that relates to the children. Perhaps you have an agreement that relates to parenting plan or a pre-distribution of the marital estate so that everybody is okay in the interim. That kind of pre-planning can set the course for a kinder, gentler divorce that is equally as ferocious and aggressive as any other divorce, but without the street fight, without the acrimony, and without the expense.
Well, that's powerful that you said that, because usually, what you hear about attorneys is pouring gasoline on the scenario, but ultimately, after it's all said and done, people have to move on. And it sounds like that approach helps people, move on in a more healthy way versus killing each other. And, it's almost a form of like light, soft mediation, because you're kind of getting some of the basic things out of the way. And like you said, the ground rules to establish a working relationship to work through the end of the marriage potentially.
It does sound that way to some extent, but I will tell you that I always take every strategic advantage. The difference here is that when you're representing people of wealth, you have the opportunity to use abundant mentality as opposed to a scarcity mentality. And so you don't need the acrimony because there's abundance, and you're able to say to both sides, everyone is going to be okay. We're going to get through this. Everyone will be okay. Whereas when there is scarcity in a relationship, that's when there's more acrimony. Not that acrimony is ever called for, but when there's abundance, it's not called for. When there's scarcity, necessarily somebody is going to have something taken from them and there won't be enough. But when there is enough, that's an opportunity for a more elegant but still aggressive process.
Mm-hmm. And let's talk about, one of the areas that you've been very successful in is working in the private equity space, or affluent business owners, male, female, of the like. But what's different about, someone who has 500,000, obviously the assets, but when you're getting into the millions and you start thinking about things like foundations and legacy, or, multi-generation wealth sometimes, what's different about that? Because a lot of attorneys don't have the skill set to be able to take on that kind of client because they don't understand the business and the moving parts. Let's talk about,
Yeah. You're exactly right. It's a whole different thing. It's a whole different world of divorce. So first of all, if you're dealing with private equity and venture capital execs and executives who have significant and sophisticated assets, then you're dealing with valuation issues. You're dealing with stages of equity. You're dealing with an unknown. Sometimes you're dealing with a wealthy, illiquid divorce. You might have illiquidity, but extraordinary wealth. And so dividing assets in an illiquid divorce and figuring out valuation dates is part of the process. It's part of the strategy. At what date do we value these assets? That's a complete discussion in and of itself. The assets are sophisticated. Sometimes you have stock options that are restricted stock units, and you've got to value them a certain way. There may be rights of refusal. There may be assets that are inchoate. You don't have them yet, but you will. There may be assets that are wrapped into miles on an airline or planes. Assets that are highly sophisticated, where it's a whole new thing. Foundations, business interests, where there is fiduciary control. You're not just talking about the dollars, you're talking about fiduciary control. In enterprising families, sometimes as a divorce attorney, I'll represent the business, not the spouse, because the business needs protection too, especially if it's a business where the owners are partners and one of the owners is going through the divorce. That means that the business may be considered a marital asset. And there may be a reason why you want to say front-end alimony and back-end property division. So you pay more alimony up front so that you can defer the property division and not injure the business. You also want to think about not giving an outgoing spouse voting shares in and fiduciary control. So this is the way in which these bigger divorces are far more complex. It's not a mathematical equation. The other piece in this is the interplay of legacy planning and taxation. So when you're dealing with a big divorce like this, and there's significant assets, then it makes sense for divorce counsel to work alongside estate planning counsel, very savvy, sophisticated estate planning counsel who can guide the divorce lawyers in taxation strategies so that as part of the divorce, you're pushing assets down to the next generation with tax minimization strategies, or you're creating charitable structures so that you're avoiding tax problems and you're benefiting the next generation and long-term goals to the maximum extent possible. And what this does also is it does create a more elegant divorce because you can do your long-term planning. You can create your legacy in connection with your divorce. You can do good to the marriage. You don't have to taint the marriage. Suddenly, the years of matrimony together and now the divorce is an opportunity to do some planning and to make it really count and to make that marriage and the enterprise that was built really count for something. So that's one of the beautiful benefits of this type of divorce.
Yeah, it's been very, very strategic. Now, sorry if this is a neophyte question, but I have to ask. I mean, at the end of the day, if people don't agree, in Massachusetts, it seems like it's one of the more difficult states to get divorced. The rules are very, very different. And if you have a judge that is, a financial focused judge, I mean, if people can't agree, is it true that it's going to be 50-50 and the judge is going to force the hand if people don't get on the same page and they're going to decide, some kind of an equitable split?
The statute does not have a 50-50 or equalization concept. The statutes, the matrimonial statutes, speak to many criteria, one of which is length of marriage. And that one is very significant. If the marriage is a long-term marriage, if you're beyond 20 years or you're at 30 years, yeah, there is a presumption that you're looking at more equalization unless there's a prenuptial agreement. But if it's a shorter term marriage and the parties can't agree, it's not going to go 50-50. If it's a short term marriage, the length of marriage is a factor. If it's very short, the courts might say, hey, everybody came in, everybody leaves with what they brought in, But it depends on the number of years, both for alimony and for property division. There's other factors too: age, health, station, employability, opportunity to acquire assets in the future, expectancy. All these are different aspects and factors that come into the conversation. But my preference as an attorney in this space is to negotiate with the other side. I like to see if I can't get to yes with no mediator, with no court, just me and the other attorney. Let's sit down, let's bang it out, let's talk to our clients and try to get to yes using communication. If it doesn't work, then we bring in perhaps a retired judge as mediator or an experienced lawyer as mediator, and we see if we can't wrap up the impasse and get through the impasse with agreement. You can always go to court. You can always argue these cases in court, but you can't dial it back. So in the first instance, find a process that does good to the marriage, because the minute you walk into the courthouse, already it creates an environment of the type of acrimony that's not good for the marriage. It taints it and poisons it and creates a dissonance that could last for decades beyond.
And in some cases, once you get to that courthouse, that both attorneys are losing a little bit of control because the judge is going to have to sign off on most of it. So that particular judge might be directing the outcome or taking a little bit of these decisions out of your hands. Is that correct?
Completely correct. And keep in mind, judges can do either or. They don't mediate the case. They don't find a balance or a level. That's not their job. Their job is to listen to the arguments and rule in favor of one side. So yes, you go into the courthouse and you take your chances. But I will tell you that there are times where that is the only way to do it. If you've got somebody unreasonable on the other side, you simply need to argue it in front of the judge. And there are many times that I say, enough, we're wasting time. Let's just put it in front of the judge, see in court, and that's, I'm trained to be in court. I love being in court. So it's not a problem. I do love to do that. And if we need to take it up on appeal, we will. My firm is known for, we will try the case, we'll bring it up on appeal. And that's what we do. That's what we're known for. But in the first instance, if it can be resolved in a less acrimonious fashion, then I think that does good to the couple and good to the marriage and lets it end quietly. And I must say also, in the bigger divorces, you don't want to drag these numbers through a courthouse. Pre-pandemic, the courthouses were filled with the public. Now that we are, post-vaccination days, the courthouses are pretty quiet. I've been to them and they're very quiet. People don't just go to court quite as frequently because so many hearings are by Zoom. But the courts are open again to some extent, both by Zoom and they're open, but it means a less public display, but still public. There are people there and you don't want to be talking about these numbers. Downtown Boston at Suffolk Probate, these are big numbers and it really, there's no elegance in a courtroom.
Right. So that's a good point. The privacy, if you're able to negotiate most of the terms, if not all, the privacy similar to, what we talk about probate, like if you can avoid probate and just have it be a really quick kind of private affair, and there's not much that will flow through probate, the better, just because it's private. You have creditors, all kinds of prying eyes looking at your stuff.
Right. Precisely.
So, as an attorney, an accomplished attorney, do you keep track of cases and peers, things that are out there? Because when you're going in front of a judge, like certain judges in Massachusetts are known for certain things, me personally, one judge I had to go through with my experience was a financial judge and didn't want to hear about any drama or anything. It just came down to the numbers and that was what they focused on. But do you have to cater kind of your approach to whoever you get assigned to as a judge?
So part of the value of having an experienced attorney is the relationships that your attorney brings. That is a significant issue. It is created through time. And it's like that in any business at all. The relationships that we bring are significant. So I do know the judges. They used to practice law for the most part. I know the clerks. I've been in front of them for decades. I know opposing counsel. And I know when I can go to opposing counsel and say, as a ground rule, let's get this couple through it as quickly as possible and not create a lot of nonsense. So, in relationship comes an ease in your profession. It happens in all professions, whether finance, whether law, whether the therapies, anything, clinical practice. Your relationships become they pave the path for our clients or our patients. And that's what we as professionals bring. So yes, it does matter. I am up to date on the cases. Every single day I get what's called slip opinions on my computer screen. I read Lawyers Weekly every week. I know exactly what cases have come down. I read those cases. I make it my business to know and to know the impact, so that when I'm dealing with the facts in a matter, I know the law in the matter and I have an immediate overlay, and I can figure out how to analyze an issue based upon the most up-to-date law. We have our finger right on the pulse. And then when I'm assigned to a judge in a particular case, I know the judge, I know the clerk, I know opposing counsel, I know my client, and I have an intuitive sense for who my client is getting divorced from. And it becomes a poetry. There's a rhythm to it. And if you're an intuitive lawyer, you're able to read the poetry, find the cadence, and manage the process with the greatest efficiencies, always understanding where your greatest opportunities are and the way forward.
Well, that's interesting that you said, because people also are buying your experience, but they're buying your network more or less too, because if you have to assemble a team of valuation people or experts, they really are buying your network as well as, your expertise and the ability to, navigate through the court system the right way. And then, like you said, poetry wise, and frame it to, the respective audience, because I know there's probably not all two judges the same. They have very different approaches with certain things. And if you put the wrong approach, it could be cross-pollinated or irritating the judge and you don't get a good outcome.
Absolutely correct. Yes.
So let's talk about just the famous a few months ago was the Bill Gates, Melinda Gates divorce. I know you don't represent them, and we're probably outsider just like most of us. But with them, the complexities, the wealth was expansive, and no one was ever going to probably walk away not living a great life financially. But in some of your higher net worth clients, they have the philanthropic side, and the Gates scenario was the foundation, where that's a big part of their legacy estate planning. They put a lot of money into the foundation. How do you kind of are these all the things that get negotiated in the future, like the roles and who gets what in terms of the philanthropy side, which is a big part of higher net worth people?
Yes, absolutely. So fiduciary control becomes an issue in these divorces. And this is one reason why having a more elegant approach, elegant but aggressive, really does make sense, because you've got two people who are very invested in philanthropy. It becomes a way of life. And they are people who are very much in the public eye. They have donated a lot of money already to many charities, and they're known for it. And they will always have their names on various placards forever. And so you want to maintain some kind of consistency in fiduciary control. You may remember the news in the very beginning of the Bill and Melinda Gates divorce, that it was right on the headlines that they were going to share fiduciary control of their foundation. That is the way to do it. And this is why having a good process that's based on abundance mentality is so important, because you want to be front-facing. These are individuals who are very often front-facing. They're in the public eye, and they have reputations. And tarnishing the reputation of a founder or a funder like this is going to potentially create an embarrassment for multiple institutions, corporate institutions, teaching institutions, academia, healthcare. You don't want that. You don't want the private life to create this kind of impact.
Would a PR firm be part of the equation to integrate the messaging? If somebody's a high profile, visible person, would PR, brand integrity type people be pulled into the negotiations?
Absolutely, if not always. You really need to have your PR person. So I do work with PR professionals, and I do work with coaches. I work on preserving reputation. That's part of my practice, is to preserve reputation. It's not just about the disentanglement and divorce. It's about preserving all of the enterprise, including those intangibles like reputation and the front-facing issues that the world sees.
Lisa, how much has your career changed with the advent of social media and kind of the stuff that you have to navigate through that, everything that a lot of people put, myself included. But how different of a ball game is it now that, I've had clients that have vilified their ex-spouse or potential ex-spouse all over the internet, saying like, really crazy things. But you've been around for a while, and I was my practice was before like social media, the Instagrams, the Facebooks were all prevalent. But I hear horror stories, and then people running in with the posts and seeing the judge, and just lambasting someone. But how has that changed the way that you have to go about what you do now?
There's evidence all over the internet, on social media. It's all over. There's all kinds of evidence. So people need to be so careful when they're posting. I recommend not posting anything that's personal other than nice photos. Keep the alcoholic drinks out of the photos. Keep all beverages out of the photos. That's not, when you're going through divorce, and even when you're not going through divorce, there's no place for that. Keep in mind that the internet never forgets, and nothing is ever gone. It's always there. When I start out in a new lawsuit, I get right on Google and I check people out. I find out what's about, what the other side is about, what's gone on. And you get so much data. It's just complete with all kinds of bits and pieces and clues that allow you to dig deeper and look farther. So I recommend to my clients, stay off the different social media sites unless it's truly work related, and is postured in a professional way. That's perfectly fine. But we don't want to have any content up there that is going to injure your own reputation.
So one of your pieces of advice would be, and I tell my clients this, is operate like a judge is looking over your shoulder for everything that you do. What your emails, what you put in writing, the way you talk, what you post is operate under the assumption that the judge is going to be seeing everything that you do at some point.
That's right. That's right. It takes years to build reputation, and it takes a second to lose it.
Mm-hmm. Mm-hmm. Well, what are some of the other things that, if I was to come in and hire you, what are some of the other things that people should think about when they're trying to find, is it that they have to love you, they like you, they think that you understand them, or is that not important?
So it really comes down to fit. I think my clients need to feel a sense of fit, that we do work well together, and fit is something that's very personal and unique. It's not always there. There's got to be the spark that this person understands me, that they get it. There's got to be an understanding between the two, that we hear each other, that we're good listeners. My clients like to know that I'm just going to be quiet and listen. And they need to know that I'm then going to think clearly and select smart, creative, mature strategies, or that I'm intuitive. So that's what my clients are looking for. There are other clients, people out there, litigants out there, who don't care if their attorney's intuitive or not. They don't care about mature strategies. They might care more about process, or whatever else. They might care more about gender or other different issues. But everybody has their own cultural view and acculturated belief of what makes the right attorney for them. It's with any relationship. You can't really account for that. Either you got it or you don't.
Yeah, it's about fit for sure. And then I know this is probably an impossible question to answer, but I'm going to ask it anyways. But how long does it typically take from start to finish if you have, your average run of the mill, things to figure out? But, I think with COVID, a lot of clients that I speak with, They were all delayed, and the Zoom and stuff. And I think it's probably you lose a lot from the Zoom. I've seen situations where judges have fallen asleep or mediators are falling asleep. But you lose a little bit, obviously, going the Zoom route, because you lose the nuances of connecting with people in front, and the body language and the facial expressions and all that. But how long does it take right now, on average?
So I would say on average, it will be a year on average from beginning to end, but this is in a situation where there is not a lot of acrimony, where there's not a lot of contest. If it's very highly contested, then it can go years, 2 years, 3 years, 4 years to get divorced. But if it's not highly contested, I would say a year. Now, that said, the courts are very backlogged. The courts in Massachusetts are very backlogged, and some judges are doing divorce splitzes. They're just getting these divorces, the uncontested ones, done one after the next. But even the uncontested divorces are very backlogged. So I would say, on average, it takes about a year, maybe 8 months before you get to agreement. And then, depending on which county you're in, it could be another 4 to 6 or 8 months before you can get into court to get the court to allow the terms of your divorce.
Mm-hmm. And then, obviously add, custody issues and things like that. That could be, all those things. If they could get figured out amicably, that's your best recommendation. The kids aren't stuck in the middle being used as weapons and things like that.
Yeah. And that does happen. And so that's very unfortunate. So yes, if there can be agreement about the children, that's ideal. That takes that issue off the table. This is why sometimes it makes sense for the couple to go to a clinician, to a therapist, to start talking about what agreements can we make that relate to the children, take that issue off the table, and then fight the fight over the assets.
Mm-hmm. So do you have like a kind of a preferred type of a case that you like? What you really just get super jazzed for it? Do you like the more complex or just the run of the mill? What's your preference right now?
I do like the more complex. I've never been one to like a simple or easy issue. I like a challenge. I like a divorce where there are assets, where there's some intellectual thinking about this. So, for example, there may be assets held in family trusts, and there may be a attempt to invade the trusts despite a spendthrift clause. It might have been that the estate planner said, oh, this trust is now, litigation proof. It's got a spendthrift clause. You can't get through it. It's ironclad. But the laws changed. The laws have changed, especially in the past about 8 years, especially since 2013. It's a constant moving target, but especially in the past, I'd say 8 or 9 years, the laws that relate to the vulnerability of trusts has changed pretty dramatically. And now family trusts are at issue and subject to being invaded in connection with divorce. And because there's so much case law, and because there are so many criteria that go into it, it's a very academic area of law. And I really enjoy that aspect of it.
Interesting. What's unique about Massachusetts compared to other parts of the country in relation to divorce and the process? I mean, I'm sure you have, global type clients that are all over the country, but what's unique in Massachusetts, do you think? Some of the both good or bad in terms of how our system is set up here?
I'm only a Massachusetts lawyer, so I only handle divorces in Massachusetts. But one of the things that I do like about Massachusetts law that I find is unique is the interplay between our divorce law, which is centuries old, our matrimonial law. It's the same thing, marriage laws, divorce laws, our matrimonial law, and our relatively new uniform probate code. So there's some interesting interplays between the very old matrimonial law and the newer uniform probate code laws. There's an interplay because there are spousal rights that are granted in connection with the Uniform Probate Code. And there's issues relating to guardianship, conservatorship, disability law, dealing with children who have special needs, and all of that body, the disability law, that impacts divorce law. So we're dealing in Massachusetts with some very old law that is case law created, and we're dealing with some new and relatively new statutory law that comes out of the Uniform Probate Code, the trust code, and out of regulations relating to individuals who have disabilities. So it's an interesting meld of old and new, which is very New England anyway, but that's what we have in Massachusetts, and it creates great opportunity for strategic interaction of the law and strategic problem solving.
And is that part of the Alif Alimony Reform Act too, or are you speaking about something slightly different?
So our Alimony Reform Act is statutory, and that is relatively recent also. That's 2012. So we have an old body of matrimonial law, but a new carve out. The alimony laws were upgraded, updated, and they make much more sense now. And it's a wonderful thing. It used to be that alimony was awarded until death of the payor, death of the recipient, or remarriage of the recipient. But now it's not payable for that long. You know, you might have a short-term marriage, and it should be matched with a short-term alimony obligation or alimony award. We shouldn't have a situation where you're married for a short term and you're paying alimony for far longer than you were ever married. That just doesn't make sense. So the laws are updated, and it makes much more sense. There are durational limits, meaning that there's a finite period for the payment of alimony based on the length of marriage. And there's the ability to deviate from that. So if there's grounds to have the alimony last longer, then upon showing good cause to the court, you can have it extend longer, but at least there's not a presumption that you're paying until the day you die.
Yeah. Does the system in Massachusetts allow for contributions from people like yourself and kind of like get together panel wise, or, you know, work through the stuff that's not working, or, you know, some reforms that need to be, is it just done on the judicial level, or do your peers and your colleagues have the ability to get together? And I liken it to like the Super Bowl or the rules committee in the NFL, where they get together and, you know, say, hey, the coin toss doesn't work anymore. We need to come up with something that's more efficient, better. But does the process allow for that?
It does, and in several different ways. First of all, lawyers who've been practicing for a period of time and who have developed a level of expertise are often on various professional associations. They're leading those professional associations, and those same professional associations also have judges on there, and court personnel, the clerks, the assistant judicial case managers, and we will talk about very high level legal issues. We talk about the cases that have been decided. We have educational programs, and we talk about what's working and what's not working. I will tell you that the Chief Justice in Massachusetts is very engaged, very involved, and wants to know what's working, what's not working. And the judiciary endeavors to fix what's not working. They make great effort to do so. The other way to do this, in addition to the process that happens when you pull together practitioners and judges and court personnel, the other way is through the legislature. And that does happen. That's how we got the Alimony Reform Act. That's how we got the Massachusetts Uniform Probate Code. So there is change. Law is a constantly evolving creature. It's always moving, always evolving, and hopefully always bettering itself.
It's a living, breathing process. It's fluid, right?
Yes.
So with that said, I would like to remind our listeners we'd love to get your followership. You can follow us, Google, Stitch, SoundCloud, YouTube, basically anywhere that you can get your podcast. We'd love to get your show, our subscription to this show. Lisa, your bio information is going to be in the body of the show, but for our listeners that want to know more about your practice and what you do, what's the best way to get a hold of you?
So I can be reached by phone at 617-966-9582. I can be reached by email at lcukier@burnslev.com, and that is spelled LCUKIER at B as in boy, URN as in Nancy, S as in Sam, LEV as in victory.com.
That's great. Well, thank you very much for your time, and love to have you back if there's some changes in the law, which we know will happen. But thanks for your expertise and your tutorials on some things to consider, both prenup and postnup, and then in the divorce route. So we really appreciate your time.
Thank you. It was a pleasure, and I'd be delighted to come back.
I've been feeling like a shark in a shrimp tank. Big fish, small pond in the shrimp